Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We have started discussing previous year questions subject-wise, act-wise for the past 3 recruitments. In this video, we are going to cover law of contracts. We are going to divide this video in two parts. Law of contract has 4 acts, and in this video we are going to cover the questions from Indian Contract Act. In the next video, we'll be covering up questions from Sale of Goods Act, Indian Partnership and Specific Relief Act. Constitution of India is done. We have also discussed questions from admin law, jurisprudence, important Latin terms and maxims. Now let's start with Indian Contract Act. The first question, the rights concerning a contract are decided by parties to the contract, Indian Contract Act, law of equity, both A and B, A, B, C. Correct answer is D, both A and B. The rights concerning a contract are decided by parties to the contract and Indian Contract Act. Question number 2. Which section of Contract Act defines proposal? Section 2A, Section 2H, 2I, 2J, 2M. The correct answer here is A, Section 2A. This defines proposal as when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Question number 3. Another question from proposal's definition. Here the definition is given and the options were recognize the definition. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal, invitation to offer, promise, conditional promise, contract. Correct answer here is A, proposal. Section 2A of Indian Contract Act defines proposal. Question number 4. An agreement enforceable by law is a contract. This is discussed under which section of Indian Contract Act? Section 2A, 2B, 2D, 2H, none of the above. The correct answer here is 2H. 2H defines agreement enforceable by law is called contract. Question number 5. What is contract as per Indian Contract Act 1872? Agreement as per law, agreement enforceable by law, agreement enforceable, law abiding agreement, offer plus acceptance. We have already seen this in the earlier question. Correct answer is B. Agreement enforceable by law is contract as per section 2H of Indian Contract Act. Question number 6. An agreement which is dash is a voidable contract. Enforceable by law at the option of one or more parties, enforceable by law at the option of one or more parties but not at the option of other, not enforceable by law, not enforceable by law at the option of one or more parties, enforceable by law. Correct answer here is B, enforceable by law at the option of one or more parties but not at the option of other. This is given under section number 2I of the Indian Contract Act. The question is talking about voidable contract, which is defined under section number 2I. Question number 7. An acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor, acceptance is complete as against the proposer but not afterwards, acceptance is complete as against the acceptor but not afterwards, proposal is complete as against the acceptor but not afterwards, proposal is complete as against the proposer. Now, when can the acceptance be revoked? Before the communication of acceptance or proposal. Correct answer here is C. Acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor but not afterwards. This is given under section number 5 of Indian Contract Act, revocation of proposals and acceptances. Question number 8. Which of the following is the mode for revocation of proposal? By the communication of notice of revocation by the proposer to the other party, by the lapse of time prescribed, by the failure of acceptor, by the death or insanity of the proposer, all of the above. Correct answer here is E, all of the above. All the above mentioned points are mode for revocation of proposal. This is given under section number 6 of Indian Contract Act. Question number 9. Which of the following statements about acceptance is false? Mere silence can never amount to acceptance of offer. Proposal must be accepted within the time limit given by offerer. The proposal must be accepted within a reasonable time. Implied acceptance is not considered as a valid acceptance. None of the above. Correct answer is implied acceptance is not considered as a valid acceptance. Here we have to find false statement about acceptance. Actually, implied acceptance is considered a valid acceptance of offer. Section 8 of the Indian Contract Act provides that acceptance by conduct or actions of the promisee is acceptable. Question number 10. Contract made by a person under undue influence is void, voidable at the option of party whose consent was so obtained, void ab initio, valid subject to express agreement of party. Correct answer is B. It's voidable at the option of party whose consent was so obtained, by undue influence. This is as per section number 19A, power to set aside contract induced by undue influence. When the consent to an agreement is caused by undue influence, agreement is contract voidable at the option of party whose consent was so caused. Contract is an agreement freely entered into between the parties, but when consent to an agreement is obtained by undue influence, contract is voidable at the option of party whose consent was so obtained. Question number 11. Which section covers contingent contracts as per Indian Contract Act? Section 42, Section 40, Section 37, 31, 39. Correct answer here is section number 31. Section number 31 of the Indian Contract Act defines contingent contracts and discusses it. Contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Question number 12. Which of the following is not true about contingent contracts? Contracting parties has interest in the subject matter in a contingent contract. Uncertain events should be collateral. It is a contract to do or not to do something with reference to a collateral event happening or not happening. Contingent contract is always wagering in nature. B and D. The correct answer is contingent contract is always wagering in nature. Contingent contracts have all the above mentioned features except that contingent contracts are always wagering in nature. Contingent contracts may be wagering in nature or maybe not. Question number 13. A agrees to pay B rupees 1000 if B will marry A's daughter C. C was dead at the time of the agreement. Which type of agreement is this? Wagering agreement, wagering contract, voidable contract, contingent agreement, C and D. Correct answer here is contingent agreement. Contingent agreement to do or not to do anything if an impossible event happens are void, whether the impossibility of the event is known or not to the parties to agreement at the time when it is made. Section 36 of the Indian Contract Act deals with contingent agreement. Question number 14. Contingent contracts to do or not to do anything if an uncertain future event does not happen, cannot be enforced, can be enforced when the happening of that event becomes impossible, can be enforced on the happening of that event, cannot be enforced by law unless and until that event has happened. Correct answer here is C. It can be enforced when the happening of that event becomes impossible. This is given under section number 33 of the Indian Contract Act, enforcement of contracts contingent on an event not happening. Contingent contracts to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not before. Question number 15. Substitution of old contract with a new one is bad in law, is erroneous but lawful, is novation of contract, is merger, is assignment. Correct answer is C. It's novation of contract. As per section number 62 of the Indian Contract Act, effect of novation, rescission and alteration of contract. If the parties to a contract agree to substitute a new contract for it or to rescind or alter it, the original contract need not be performed. Question number 16. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it, not to restore it but to make compensation for it to the person from whom he received it, to restore it but not to make compensation for it to the person from whom he received it, neither to restore it nor to make compensation, none of the above. Correct answer here is A. To restore it and to make compensation. This is section number 65 of the Indian Contract Act, obligation of person who has received advantage under void agreement or contract that becomes void. Question number 17. I think this is a repeat question. This question must have come twice. So we'll just move to the question number 18. Question number 18. A singer contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months, and B engages to pay her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theatre and B in consequence rescinds the contract. B must not pay anything to A. B must pay A for 5 nights for which she has sung. B must pay A for all the nights under contract. B must pay for 6 nights, none of the above. Correct answer here is B. B must pay A for 5 nights for which she has sung. This is section number 65 of Contract Act. Obligation of person who has received advantage under void agreement or contract that becomes void. So when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. This question is from illustration C. A singer contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months. Question number 19. When a contract has been broken, compensation for any loss or damage caused to an aggrieved party shall be given for the loss that naturally arose in the usual course of things from such breach. Compensation is not to be given for any removed and indirect loss or damage sustained by reason of the breach, the loss which the parties knew when they made the contract to be likely to result, either A or C, either of the above. Correct answer here is D, either A or C. As per Indian Contract Act, section number 723, compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such a breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Question number 20. What are the rights which are available to an indemnity holder as per the Indian Contract Act? Damages, subrogation, refuse indemnity, all of the above, both A and B. The correct answer here is A, damages. This is given under section number 125, right of indemnity holder when sued. The promise in a contract of indemnity acting within the scope of his authority is entitled to recover from the promisor all damages which he may be compelled to pay in any suit, all costs which he may be compelled to pay in any such suit, all sums which he may have paid under the terms of any compromise of any such suit. So you can read all this detail, section number 125 of Indian Contract Act. Question number 21. Where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as co-surety, the contract is void. Guarantee is not valid. Guarantee is not valid if that other person does not join. Guarantee is abolished. Surety is discharged. Correct answer is C. Guarantee is not valid if that other person does not join. This is section number 144 of the Indian Contract Act. Guarantee on contract that creditor shall not act on it until co-surety joins. Question number 22. A gratuitous bailer is duty bound to disclose to the bailee faults in the goods bailed which bailer is aware of, disclose the defects which are immaterial, disclose the faults which may not expose the bailee to extraordinary risk, disclose to the bailee a list of all possible faults which may or may not be present in goods but may arise in future, disclose to the bailee the things bailee should be careful about. Correct answer here is A. The gratuitous bailer should disclose to the bailee faults in the goods bailed which bailer is aware of. This is section number 150, bailer's duty to disclose faults in goods bailed. Question number 23. It is the duty of the bailee to return or deliver the goods bailed according to the bailer's directions on demand as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished, on his own, on demand, as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. Option number C, according to the bailer's directions without demand. Option D, on his own without demand as soon as the time for which they were bailed has expired. None of the above. Correct answer here is C, according to the bailer's directions without demand, as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. This is section number 160 of the Indian Contract Act. It is the duty of the bailee to return or deliver according to the bailer's directions goods bailed without demand. Then coming to question number 24. If the pawner makes default in payment of the debt or performance at the stipulated time of the promise, in respect of which the goods were pledged, the pawnee may bring a suit against the pawner upon the date of promise, may retain the goods pledged as a collateral security, may sell the things pledged on giving the pawner reasonable notice of sale, may bring a suit against the pawner upon the date of promise and retain the goods pledged as collateral security, may bring a suit against the pawner upon the date of promise and retain the goods pledged as collateral security, or he may sell the things pledged on giving the pawner reasonable notice of the sale. You can pause the screen, read the question and the options again. The correct answer here is E, may bring a suit against the pawner upon the date of promise. This is given under section number 176 of the Indian Contract Act, pawnee's right where pawner makes default. So these were all the questions from Indian Contract Act. We'll stop here in this video. In the next video, we'll be discussing questions from Specific Relief Act, Sale of Goods Act and Partnership Act. In 2023 recruitment, there were 25 vacancies and 12 of our students got selected as SEBI legal officer. We are so proud to contribute to so many successful journeys over the past 3 years. We at iExamB help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.